Can you describe some of the benefits of victim impact statements for victims of crime?
The law on victim impact statements in South Australia doesn't actually prescribe the purpose of a victim impact statement.
Okay.
So when a victim reads or is reminded of their entitlement as prescribed under the Victims of Crime Act, it in basic terms says that a victim, who can be any person who has suffered harm as a result of an offence, a victim has a right to make known to a sentencing court the harm that they have suffered, is really the general principle. How does that happen? Well, one of the sections in the Sentencing Act of 2017 says that a prosecutor is required to furnish particulars of any injury, loss or damage that has been suffered. But once again, it doesn't say how that will be done. That section goes on to say, however, if a victim makes a statement about that harm, whether it be injury, loss or damage, and wants to read that statement in court, then the prosecutor should lodge an application to the court to allow the victim to do that. And if the court agrees, then the follow-up section, which actually uses the term impact statement, it comes into effect. And what that section says is that a person who is a victim of an indictable offence or a prescribed summary offence has an absolute right to either read or ask the court to cause to be read their impact statement. So the concept of a victim impact statement really is a formal way of gathering the information to honour the victim's right or to help the prosecutor fulfil his or her obligation to furnish particulars, or in the case of indictable or prescribed summary offences. So prescribed summary offence is where someone has been killed. So for instance, in a car crash where the person's being prosecuted for the summary or minor offence of driving without due care or consideration, or in an industrial offence, or where a person has suffered a permanent lifelong disability. I can't remember precisely how it's worded in law. So in those cases, then a victim can read their victim impact statement. So when you put all three pieces of law together, essentially what it says now in South Australia is that if you suffer harm as a result of an offence and you are not the perpetrator, then you can either, if it's a non-indictable, non-prescribed summary offence, you can ask the court for permission to either read or have the court cause to be read out your victim impact statement, or to receive your written victim impact statement, or your verbal victim impact statement given via recording, whether it be just an audio recording or an audio-visual recording. If you're the victim of an indictable or prescribed summary offence, then you have the right to either read it out, ask the court to cause it to be read out, or deliver it by some other means, such as an audio recording.
Right.
The court is then obliged in the Sentencing Act to take into account certain factors. So the prime consideration in sentencing someone is community safety. Then below that there are some secondary considerations, and one of the most important of those secondary considerations is the harm that has been done, which includes the effects of the crime on the victim. And so it's now a relevant factor in sentencing, has in fact been a relevant factor in sentencing in our codified sentencing regime, that is where it's been written into law since the April 1989, when the then Criminal Law Sentencing Act came into effect, and that particular law was just replicated when the new Sentencing Act of 2017 came into operation. In the victim impact statement, the victim can not only talk about the effect of the crime and their personal circumstances, but now, if they choose to do so, they can make some comment on the sentence as well. And a court cannot rule a victim impact statement inadmissible purely because a victim has made some comment on sentence.
Okay.
And that's quite unique. as
To South
to
Australia?
South Australia,
Yes, okay.
and also unique to South Australia when compared to other jurisdictions in Australia.
Yes.
Is the ambit of who can make a victim impact statement. So when the 3 people were murdered, for example, at Kapunda, there was nearly 3 dozen victim impact statements covering the immediate family member who survived, a close family like uncles and aunts, but also friends of the deceased, and also a spokesperson for the community of Kapunda, who talked about, more broadly, how this most heinous crime had impacted the community as a whole. And all of that information was able to be put because of how broad our definition is. In addition to having those individual type victim impact statements, in South Australia we have 2 other forms of victim impact statements, both of which the Commissioner for Victims' Rights is the primary person responsible for their preparation and submission. The first is a neighbourhood impact statement. So that a way of thinking about that is imagine, for example, that you were to return to your home and find that your neighbour is now involved in drug dealing, and as a consequence of that drug dealing, there are more vehicles coming to your street, there are syringes being discarded on your front garden, there's offensive language and all sorts. So your quality of life is impacted, and there may be other effects as well. But you have a fear that if you made an individual victim impact statement, then you'd be identified with that and there may be some form of retaliation. So what a neighbourhood impact statement would provide for is that the houses that are immediately proximate or alongside of the house where the drug dealing was happening could all come together and make a collective statement so they could maintain their anonymity but still have a voice in the sentencing to help the court assess what harm had been done. Imagine a bushfire. Would it be reasonable for a court, for instance, to take 200 or 300 victim impact statements, or would it be better for the court to get a statement that reflected broadly the harm that had been done to that neighbourhood, to that community that had been affected? And I, as Commissioner, did neighbourhood or impact statements in a case involving an arsonist where there were more than 13 fires, a bushfire, a school where one of the staff had perpetrated sex offences on students and it had impacted the entire school community, and also in relation to a drug, the largest drug laboratory at that time known in South Australia, which was a place in the Riverland, and which was a small community, a permanent community of only about 50 to 100 people. Excuse me. And then the other type of victim impact statement is a social impact statement, and that's meant to reflect the broad harm that's been done to the community of South Australia. And given that crime is an offence against the individual who's harmed as well as the public at large, it makes sense that a court receives information about the individual harm as well as the collective harm. And so I made a community impact statement about the impact of domestic violence on the community more broadly. I made a victim impact statement in a murder case in the remote far north Aboriginal lands because of the broad impact that crime had on over 2,500 people. And we've made a statement, I'm just trying to remember one on amphetamine driving and the risk to other road users at large, and whilst the court grappled with whether or not there was a way of substantiating at what level is a person affected by amphetamine for the purpose of driving under the influence. With alcohol, we've set these arbitrary figures of 0.05 and 0.08 and so on, with the graduated that's attached to the different types of penalties. But when it comes to other types of drugs, we haven't necessarily. And with amphetamine use, there's great ambiguity in the academic research world about where the level is pitched and what impact it has. And that's due to the different methodologies that have been employed in the various studies. But for the public at large, that as a road user, that's not as relevant as the fact that someone who's consumed amphetamine does pose a risk to other road users. And that's the point that I wanted to make to the court. And those community impact statements are unique to South Australia. There are several other jurisdictions where variations, such as Canada and England, where there are variations on the notion of community impact statements and neighbourhood impact statement, particularly in the context of drug-related crime. There are states throughout the United States where they can make that type of statement. But South Australia is possibly the only place in the world where you have all three types of victim impact statements coupled with, for individuals, no matter whether it's a summary, a minor offence, or a major indictable offence, or prescribed some offence, it doesn't matter. As individuals, they have a right of elocution, a right to come and tell their story, have their day in court. Why do we do it? Well, there are three basic reasons according to the literature. One of those relates to the accused. There is a school of thought that once the accused is made aware of the human aspect of his or her offending, once they're made aware of the actual harm that they've caused, then that can have a rehabilitative effect, and it might drive them to offer, for example, by way of a reparation, a genuine apology, and it might help enlighten them in terms of understanding more what the true consequences of their offending are, whereas the law is a very sterile, sort of black and white, stark way of defining what actually happened. From the point of view of the court, there is always been provision from the early days of the common law system through to the 18th and 19th century, when we saw the actual adversarial system be cemented into our process of justice, and even today, there's been a consistent acceptance that the harm that has been done is a relevant factor in sentencing. And in the old days, the court used to have to make an assumption. How would a reasonable, prudent person feel having been raped? How would a reasonable person feel having been woken up in bed, or whatever the crime happened to be during a home invasion? And now the court, albeit that it adds a bit of emotion to it, the court actually gets information that is pertinent based on each individual case. And then in the context of equity, which then filters into the reasons we do these for victims, in the context of equity, it means that the court now is getting submissions from the now guilty offender, from the state in terms of the broad public interest, and from the person who's actually harmed. And that equity component feeds into the concept of procedural justice for victims. The other is, from a victim perspective, about 90% or over 90% of cases are resolved by guilty pleas. So if it wasn't for the provision of victim impact statements, they'd have no role in the actual criminal proceedings. They'd have no opportunity to tell their side of the story, to be able to, through the court, obtain validation and vindication. So there's a belief that the guilty plea and the admission, etc., and a formal finding by the court that this crime did happen helps vindicate the status of the individual as a genuine victim. And then the validation comes that, having heard the victim impact statement and heard how the offences harm the victim and so on, that through the acknowledgement in remarks by the magistrate or judge in sentencing, that helps validate and gives the victim some sense of justice. And I think that's really important. Also important is that there's no evidence to show that victim impact statements have unduly impacted upon offenders' entitlements. And in particular, here in South Australia, the major evaluation in the mid-1990s showed that victim impact statements had no statistically significant impact on causing sentences to become harsher. But they had actually statistical significance in enhancing victims' perceived satisfaction, or sense of satisfaction is a better way of putting it.